Hey everyone, it's Rob Ryder, and it is Sunday, October 20th, 2019. Ask and ye shall receive. What does that mean? Well, you ask for the appointment of a receiver. Because receivership is a common law remedy. It's the most invasive remedial tactic. So say attorneys. What does invasive mean? Entering on to another's possession with hostile designs, aggressive. Somebody is going to aggressively apply a remedial tactic. And the question then becomes, well, can you appoint a receiver? And I say that you can, and I'm going to show you where it says. And, that receivership doesn't go with bankruptcy. It goes with common law. It's an equitable remedy. So let's get there. Hey, but first, Rob Ryder's email address is courtofrecord@AOL.com. Phone number 616-712-6179. If you can, until these things work, because until then it's just talk. But I'm trying, right? If you could donate to Rob Ryder at AOL.com on PayPal, or just stick it in the mail to Robert Allen Retluski, 10955 42 Mile Road Northeast, Rockford, Michigan 49341. I don't want to dwell on that part. I want to get to the good stuff. So what is this all about? Well, let's go here first and look at the definition of receivership, right? So in law, receivership is a situation in which an institution or enterprise is held by a receiver, a person placed in custodial responsibility for the property of others, including tangible and intangible assets and rights, right? Intangible rights, outstanding, like your right to liberty, your right to due process, your constitutional rights, right? These people can take custody of them, make sure they're being enforced, especially in cases where a company cannot meet financial obligations or enters bankruptcy. The receivership remedy is an equitable relief that emerged in English chancery courts where receivers were appointed to protect real property. Receivership are also a remedy, listen to this now, of last resort in litigation involving the conduct of executive agencies that fail to comply with constitutional or statutory obligations to populations that rely on those agencies for their basic human rights. So in a nutshell, what you do is you petition against the agency, right, in a court case, and then your first thing you ask for is you apply for receivership. So you're going to give them basically a verified complaint, right, and then ask for receivership, and that's what you give to the court. I think that's what happens, right? When we get down to the brass tacks, that's what's going to happen is file a petition into the Court of Equity, which here is the circuit court, state your claim, and then ask for a receiver to be appointed. And if the court agrees, well, then they can appoint a receiver, not over you, over the entity that you're having a problem with to get your shit straightened out. So, because I had read this stuff and I thought about it, so I know what I'm going to do, because I have this case going in the Veterans Claims Court. In equity, right, I put in an application, appointment of receiver, because it says federal courts can provide receivership also. So application, appointment of receiver. Notice, petitioner applies for a receiver to be appointed by the court due to secretary's failure to comply with constitutional or statutory obligations owed by the United States to veterans in general, and Robert Allen Retluski, petitioner specifically. Robert Allen Retluski, Staff Sergeant, Veteran USA. And by the way, if you're a veteran and you're enlisted, well, you're still in the military. They won't give us the ID card. That's one of my bitches. But I've shown in my previous videos that, we're still in the military. Title 10, United States Code, Section 506. Right? If you enlist during a time of war or war starts, well, then you don't get out until the war ends. And they consider everything a war. We're always at war. So once you enlisted, you're a soldier, sailor, Marine, wingnut, coastie for life. Okay, so that's all I put, right? One sentence. How hard can it be, right? And apply for a receiver. Check. I did it. Now we'll see what happens. But that was to, take care of this. I'm saying that the Secretary of the Department of Veterans Affairs owes me this duty, because he's the United States' agent. Well, because he won't do it now, what should happen is the court's going to go take over the Department of Veterans Affairs and get me a remedy. If it happens, it will be, let me go back to that again, because you can go, if you go to this court, Google it, United States Court of Appeals for Veterans Claims, you can see this docket button and put in 19-1910 and then ask to see the full docket and blah, 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 and it'll show all the entries have been put into this court case. You want it to run a report, basically. And then this would be, if it goes in, it would go in tomorrow. So that's how easy it was to do. So I didn't want to overthink it. I just go ahead and do it because, I had read in Michigan, again, that this is the rule. It says appointment of a receiver. Rules 2.622, these are the Michigan court rules. Rule 2.622, receivers. The appointment of a receiver. Upon the motion of a party or its own initiative or good cause, the court may appoint a receiver as provided by law. Well, by what law? By common law. This is a common law, equitable relief. A receiver appointed under this section is a fiduciary for the benefit of all persons appearing in the action or proceeding. For the purposes of this rule, the receivership estate means the entity, person, or property subject to the receivership. So even if you're going to criminal court, you need to put in an application for a receiver, right? Because you're not being charged for a crime. They're writing these bonds and creating negotiable instruments, and they're trading off of your name and your signature, and they're going to warehouse you because your account isn't worth enough to pay off the debt yet, but it will be because every year you're getting your stipend. We're under some prepaid system that they don't want us to have access to. But for me, a perfect example is the things with the veterans. It's like I was a veteran, I did my time. Well, they have a remedy where I shouldn't have to struggle the rest of my life. And technically, because we're under martial law, gold fringe flags in courtrooms, the veterans are part of the governing force that out here in the federal districts. So we shouldn't run from it. We should run towards it. And the court's going to be the one that selects the receiver. Blah, 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 blah. Okay. Start closing some of these things out. So that's done. That's done. And the Florida rules of civil procedure, right? Here they call them court rules. In Florida they call them rules of civil procedure. There's a section on receivers. So I have to believe that every state is going to have some statute, rule. Well, these aren't statutes. These are rules. These are court rules, right? This is just another name for a court rule. They have a rule for receivers. And it talks about how they're going to be, notice the provisions of the section before this as to notice shall apply to applications for appointment of receivers. So basically, if you're asking for the appointment of a receiver, the worst that you would have to do, if you're the one that's, wouldn't matter if you're the defendant or prosecuting, right? In one case, you're already in court because they're trying to take your house. In another case, you're trying to enforce some rights, which means you're filing a petition with the proper court. But in either case, once that's done, you should be able to ask for a receiver. And then, according to these Florida rules, every receiver shall file with the clerk's office a true and complete inventory under oath of property coming under the receiver's control or possession under the receiver's appointment. Within 20 days after the appointment. Every 3 months, another one. So they got to keep the court informed. I think in a foreclosure in Florida, and I'm going to show you my evidence, that they've actually appointed a receiver, but the receiver's not sending the report. That it's more like this. When a receiver neglects to file the inventory and account, the court shall enter an order requiring the receiver to file an inventory and account and to pay out the receiver's own funds, the expenses of the order and the proceeding thereon within not more than 20 days after being served with a copy of such order. In other words, the court is in control of the property, and the receiver is acting like an agent for it. And they're supposed to be sending this paperwork in to the court, but if they're not, well, what can happen? Well, then they're going to have to pay out of their bill, out of their own money, because they're investing it, right? Amount remaining in the hands or invested by the receiver, because the receiver's acting as the agent for the court, which is actually holding the property. So instead of them making a decision and saying whose it is, they're keeping it in limbo, and they're making a fee out of it. And I think that's what when you go to court for foreclosure in Florida, that's the person you're going to see for all your hearings and so forth, is a receiver. So let me show you some evidence of this. This is really cool. So I was helping this gal down in Jackie. I was helping her in her foreclosure, and this is Lake County, Florida, right? Lake County Clerk, Florida. And let's just go up here real quick. Case number 35, 2019, CA 001306-AXXX. Right, so that's what the clerk calls a case. And it's funny, if you start going through all of these docketed items and all the different styles of case numbers on, there aren't any of them using this style of case. Unless Jackie may have used it, and I may have used it, but they're not using it. It's not what the attorney uses. It's not what the judge uses. It's not what the clerk's attorney used. Right? They're not using this style of case number on their documents, which, if you don't have a chance to look at the documents, you wouldn't know that. But way down here on October 4th, I put in Jackie put in, I wrote it up for her. This motion for leave to file a bill of petition of right. Right, into the court, blah, 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 stamped by the clerk, right? This is clerk of the circuit and county court, Lake County, name of some town, Florida. This was the bill of petition of right. And so this is where I shouldn't have called this a motion, right? Because it really isn't a proper case in motion. It's a bill of petition of right, right? So it by itself should have been enough. I should have just put bill of petition of right, left this stuff off, right? Because a bill also moves the court. Because once you say it's a motion, then they want to put it on the motion docket calendar. They don't have any times for you to do that. But if it was just business for the court, it would go on the court docket, which is different than the motion docket, right? And this is court business. It really isn't a motion business. It's filing a bill of petition, not putting a motion into a court case, filing something else about a court case. That was my thoughts, at least, right? And so what I was saying in here is that, that Jackie's the petitioner. I'll just read it. It won't take that long. Hang on here. Make it a little. So Jackie, petitioner, herein respectively shows unto this honorable court that by acts of bad faith, licensees of the state of Florida rendered the petitioner insecure in a person's papers, houses, and effects of unreasonable searches and seizures, and that made petitioner the victim of larceny, bad faith, simulated legal process, under color of law, ongoing before this court, from which the petitioner seeks relief. Petitioner is in possession of land in Lake County, Florida, granted, bargained, and sold to petitioner by deed recorded in, that's the way they show it on the deed, so I put it in that way. Now in the custody of the name that was on the deed, so I put it in that way. The grantor of said deed acknowledges that the grantor was in hand paid by grantee on or before 19 November 2018. Petitioner has not received any form of certificate from the state of Florida evidencing the transfer of the legal title to petitioner, indicating some scheme offending the public trust. The state of Florida licensee, right? So somebody licensed by the state of Florida, like a real estate agent or a closing agent or a title company or whoever it is, right? That's what I'm talking about. The state of Florida licensee who prepared this indenture omitted petitioners, that's the grantee, her full legal name. Identification from the deed, replacing the petitioner's person with the thing, right? Your name with the middle initial, comma, a single person, or however they do it in your state. They don't ever put your full legal name. They don't put Jacqueline Victoria VZ on your warranty deed. No, they put Jacqueline V. VZ, comma, a single person. All right, so they took your person and made you into a thing. Basically took your spirit. Plaintiff's complaint includes a document titled mortgage, some form they use, upon which the thing, Jacqueline, right, was made the mortgagor, but no mortgagee is identified. And the mortgagor thing does not exist. And no mortgagee is, or as the mortgagor, the thing, Jacqueline V. VZ, does not exist. And no mortgagee is identified. This instrument is legally insufficient to bind petitioner's person or estate. The lender did not sign a contract with petitioner or mortgagor, and no loan was made. So if you didn't know this, right, the lender never signed a contract with you to lend you any money when you were buying your house. They may have their name on a contract, but it wasn't signed by them. They don't sign a contract. That deal never happened. We're being taken advantage of by loan sharks, which is another thing that receivership is for. And this video doesn't get too long. I'll read a little bit of a book about that. The plaintiff's complaint also incorporates promissory note that is not recorded in Lake County, Florida, official records as required by law. And it's been stamped, paid to the order of. This is just the way they've always been, right? They take your note and they stamp it, pay to the order of. And that's an endorsement. And that endorsement turned it into a check. It's paid to the order of. Well, they'll do one and they'll put their name in and have it deposited. But then they'll do another one, which is, this is one way they do it, and then that one will be blank, and it'll be a blank endorsement. Well, if you put your name on there, you could have it cashed. But the point is, they took your note and they converted it to something else, and once it was converted, it canceled out the debt. It's called extinguishment. Right? So if your note has paid the order of, then the debt's been paid. And that's the evidence. No cause of action has been identified by, and if it's not on the note, there should be an allonge to the note. I need to say that because sometimes it's on the note, but some places they do a thing called an allonge, A-L-L-O-N-G-E, which should have been filed with the note into the court case, but they sometimes forget to do that. But if they're using an allonge, the allonge will have this endorsement on it. So those things, you have to ask about. Or you don't. You just have to put in the thing and then ask for receivership and let them figure it out, which is really all this is. This is like the probable cause of, hey, shit's going on. I want you to appoint a receiver. Although when I put this in, I didn't know we would be asking for a receiver. Hey, that's where we're at now. We're going to ask for a receiver. No cause of action was identified. Blah, 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 blah. I don't want to read any more of this. But okay, so here's her warranty deed just to show you. There's the thing, Jacqueline V. VZ, a single person. All right, well, that's not her name. So that's what's wrong. And, so now the record doesn't have your name on it, and in a court of law that's just looking at the record, no matter what you say, you're not going to have any standing because this is not who you are. But this is who has the warranty deed. Because, they can give a warranty deed to a business. So this is just a thing. This is, right now, it's an unregistered DBA. You could be doing business this way. But if you use any name other than your full legal name to do business, then you have to have, filed a DBA to use the name you're using. So, if you're saying that that's you, then basically you committed a crime because, you didn't file it. All these are truisms, but it doesn't seem to make them do anything. So, because of what it says about receivership, we're going to see if that does anything. Anyways, I read that to say, well, we put that in on the 4th. Well, then on the 8th, because the 4th was a Friday, on the 8th would have been like a Tuesday. For whatever reason, the judge put this in the court case, which is a return mail envelope, which had to do with order granting judicial default being sent to... Go ahead and turn around here. Let me rotate you. Oh, there it is. There. Right to the Federal Deposit Insurance Corporation as receiver for Colonial Bank, blah, 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 some address. Well, the address is wrong, so this thing got kicked back. And but if they were doing this to one of the parties, because this is one of the parties to this court case, right? And so it's not the Federal Deposit Insurance Corporation. It's this whole thing is the name of a thing that replaced the person, Federal Deposit Insurance Corporation. Right? Federal Deposit Insurance Corporation probably exists properly. This is just made to look like it's that, but it really isn't the Federal Deposit Insurance Corporation. It's a thing that's using that as part of its name. Well, they got the address wrong. So it got kicked back, right? Return to sender. Well, who sent it? Heidi Davis. H-E-I-D-I. Heidi H-E-I-D-I. Davis, Circuit Court Judge. I spelled her name wrong. H-E-I-D-I. That's how you spell Heidi. Lake County Courthouse. This address. Right? So she's the one that mailed it, and it's being returned to her. So it went to the circuit court clerk, right? That's this right here. But then I had this received stamp, right? Heidi Davis, circuit judge. Well, who receives things? Receivers. That's what I said. So this I said, I gotta go see what this means. What does it mean for somebody to receive something, right? And that's where I got a clue about, hey, there's this thing called receivership, and I think she's acting as a receiver right now. So that came in, all right? So then some more things happen. And this is just, the way the Holy Ghost works now, because there was already a hearing scheduled for this motion for dismiss and motion to strike that the plaintiff's attorney had put in, that the hearing was going to be on the 14th. And they were asking to dismiss the dismissal of Jackie, who had asked for the case to be dismissed, right? But this was to, I'm not used to having it so easy to show the documents. I just got to click on the button. There you go. Plaintiff's opposition, right? It's really not a motion to dismiss. It's an opposition to dismiss. But it's a motion to dismiss the dismissal claim of Jackie. So those were going on. So they had to have this hearing. So this paper went in. We got this thing was put in the mail. These things happened. Jackie goes to court. And so she asked the judge, if this was a court of equity. Because that's the court we were trying to get in, right? That's where these papers like a petition should go. It should go to court of equity. And the judge said to her, said no. He said this is a court of private law and statute. And Jackie said, well, then how do I get my motion heard in equity? And the judge said, again, the motion is this thing she put on the 4th, right? Not that one, the other one. Just leave it open. All right, how can we get this thing heard? And the judge said something about, snarkily about she should read the civil procedures. But then she said, which makes sense now that she said that, because she's not lying. The judge isn't lying. It's just, what is she really saying? She said, well, Jack, you should read the civil procedures. But that to have her motion heard, she'd have to go to case management to have it heard, to have it scheduled. So then Jackie went to have that done, and started to get a runaround. That's kind of where that was left at that point. But the next day, right, the judge puts this motion here, for leave to file bill of petition of right, filed pro se by defendant Jacqueline Victoria Vesey. Right, this one said motion for leave to file bill of petition of right. This one says for leave to file bill of petition of right, filed pro se by defendant Jacqueline Victoria Vesey. Well, she didn't file it pro se. See, pro se isn't in the Court of Chancery or Court of Equity, because in the Court of Equity it's proper persona. Everything's done in person. And she's not the DFT, which, we could guess what that means. It's like, well, they mean defendant. But it doesn't say defendant. It says DEFT, so I don't know what it means. Right? But it doesn't say petitioner, so it's not Jackie, right? But then they have her name on here. So there were things wrong with this narrative they put on here, but this thing got filed anyway, so what the hell did they file? What they filed was what Jackie had after she got, had it recorded with the recorder's office. This is this thing. We got a copy and we mailed it to the judge. And the judge put the same stamp on it, received. Right, so we used this address right here. Right, so if you wanted to send something to the judge, you would have to ask him for the judge's address, because you're not always going to have this return card here, but the judge's got a mailing address. So the biggest thing is, well, what's the suite number, right? Because that's their physical location. Anyways, the judge put this into the court case. It's the same paperwork. And it's got a copy of to Heidi Davis, Circuit Court Judge, Lake County Courthouse. It's got these inspected stickers on it. They did some interesting things with this paper. They did the same thing here, inspected. Right, so those are all interesting things. So we did get it to her, right? So now we could just file, well, what we're going to do, I haven't talked to Jackie about this yet, but we're going to file for application to have a receiver put in. So that's what was going on in this court case, right? It's like, hey, they called it received. And in my court case, the one with the VA, if you look at the docket and look at all the entries, a lot of them have the word received on it. Received, received, received. And then some of them didn't. It's like, well, why are they receiving some and not others? But what about a receiver? So let's go to Bouvier's. That's my favorite for this type of, getting the definitions for. You can use blacks. It doesn't really matter to me. But what is a receiver? What's chancery practice, first of all? So you're in the court of equity. We're talking receivers. You're in chancery, right? So who can ask for a receiver? Anybody can apply. How do you move the court? By application. Apply for a receiver. Right? Because you want to get into chancery. That's where acts of good faith matter. A person appointed by a court possessing chancery jurisdiction to receive the rents and profits of land or the profits or produce of other property in dispute. The power of appointing a receiver is a discretionary power exercised by the court. The appointment is provisional for more speedy getting to the estate in dispute and scouring it for the benefit of each person as may be entitled to it and does not affect the right. So they're not going to change the rights. They're going to just determine who has the right. And in that property, you have the right. Certainly the people who brought the court case don't have a right. So that's for property like that. But, like in a criminal case, nobody has a proper oath of office. Right? I don't know how else to say it. If you could go look at their oaths of office from the township clerk all the way up to the Supreme Court justice, chances are they're not using their full legal name on their oath of office. And if they didn't use their full legal name on their oath of office, then they hid their identity and they really didn't take an oath of office. They just pretended to. Well, that's, sabotage. That's spying. That could be construed as treason. You got to be careful doing shit like that. And beyond that, most of them take an oath where they say, "So help me God." Well, that's a religious test, and that violates the 6th article of the Constitution. Well, in the 6th article of the Constitution, not only does it say you can't take a religious test, but it says you have to take an oath to support the Constitution. If you look at the President's oath in the 2nd article, it doesn't say support. It says protect and defend, but it doesn't say support. And the 6th article specifically says an oath to support the Constitution. Well, as it turns out, and I've showed this in many videos, right, the very first law that was passed by the first Congress after the ratification of the Constitution, and it's found in 1 Stat, S-T-A-T, 1 Stat 23, is the oath of office that satisfies the 6th article of the Constitution. And it says who has to take it. And basically everybody has to take it. So they may have to take more than one oath of office for an office, but they certainly have to take this oath of office to have any office to support the Constitution. And then other offices have other ones, because this is for everybody. So Donald J. Trump, right, hasn't taken the oath in 1 Stat 23 as Donald John Trump. And when he did his inauguration, he says, "So help me God," in the words, or he's asked by Justice Roberts, "So help me God," right? And so he repeats that. But it really isn't in his oath when you go look at the 2nd article. It doesn't say, "So help me God." So he did take the proper oath, but he said, "So help me God," and you could say, well, that's after the oath, right? It's after the period. It's not part of the oath. Yep, I would agree. Because, it's not in his oath. But he still needs to take it as Donald John Trump, not Donald J. Trump. So none of these people have a proper oath of office. So that's your first thing to say is they've made all crimes commercial and they're after some kind of bond or other negotiable instrument. And whether you think it's a criminal case, tax case, federal, state, whatever, just ask for a receiver. Put it in. And see what happens, right? As simple as one line, putting it in. And so, I hope to be able to prove it next week because this is in, and you can all go look yourself to see what happens next. But there it is, right? Appointment of receiver. I've already asked. Is it really this simple? Do I just need to ask for them to appoint a receiver in the place of Robert Wilkie, Secretary of Veterans Affairs, and have the appointed receiver do for me what Robert Wilkie is supposed to do, but so far has failed to do? And he hasn't just, failed to do it for me. He's failed to do it for everybody. Well, you could say the same about Social Security. You could say the same about the House of Representatives or the Senate or any of these people. It looks like the strategy is to file litigation, a petition, right? Petition grievance, your grievance of the government, and then apply at the same time for this receivership. So, okay, hey, that's the the nuts and bolts part. Now I'm going to just read some of the things I read that I think are interesting, and I hope that you stick around to hear it. But again, I didn't say this stuff. This is all the stuff that I was reading here in the last couple of days that just reinforce the idea that we need to be asking to have a receiver. So here is injunction and receivership proceedings against illegal lenders. That's who your lender is. Your lender on your warranty deed or on your mortgage or deed of trust, right? They're not really the illegal lender because they never signed a contract with you. That could be a proper name of a lender. It could be a proper address. It could all be proper. But they didn't sign an agreement with you. And they're not the ones that your payments are going to go to. They're going to go to whoever it is you get set up in your escrow account. right? But it's not going to the lender. It's going to a loan shark who pretended to be the lender. And the way we stop that is with an injunction and asking for receivership. So let's read about it. Loan sharks are not usually imbued with the respect of the law. Invasion of various legal controls is indispensable to the success of their enterprise. And operating as they do outside the law, they inevitably acquire a contempt for that which they have profitably defied by means of their various stratagems. So eventually they'll be committing contempt of court because, they got these various ways of doing this. The lawless attitude of those engaging in loan shark enterprises is a foremost reason why a loan shark continues to thrive, and the problems he creates remains a serious one, despite a marked increase in recent years in the number of scope regulatory laws relating to the field of consumer lending. This is written in the 20s. The illegal lender's method and design to place the borrower in a position where he cannot make use of ordinary remedies. The legal machinery available to the borrower is often too cumbersome, expensive, and otherwise inaccessible. And the prosecution of the actions by individual victims seeking redress was nowhere seriously retarded the loan shark's vicious practices. Has here seriously retarded. The victims themselves are usually uninformed persons who are incapable of defending their own interests or even of affording the time and money necessary for the litigation attendant upon a defense. Doesn't that sound like a foreclosure case? While the lenders with whom they deal are invariably possess resources and employ methods far beyond the powers of their victims to oppose. The big bad bank, the enormous aggregate operations of loan sharks, their disregard and planned circumvention of private rights, the calculated and defiant contempt of law, their brazen use of minor courts as weapons of oppression. Did you hear that? The brazen use of minor courts as weapons of oppression, and the devastating effects of their piratical onslaught upon millions of obscure people clearly provide a problem of general concern and one which defies solution by unorganized individual attacks. Oh, you mean it's a class action lawsuit? Ain't that something? So this is what's going on, right? That this loan sharking is really what your mortgage is all about. In champion them to the state in a number of jurisdictions, they sought to eliminate the operation of illegal lending enterprises by resort to the equitable remedies of injunction and receivership. Right? Eliminate the opposition of illegal lending enterprises by resort to the equitable remedies of injunction and receivership. And the receivership is subordinate to the injunction. So the idea is first you got to, put in your sworn affidavit asking the court to get involved, right? And then the first thing you apply for is receivership. So it goes on to say then it is the duty of a court of equity, in common with all courts and all institutions, to adapt its course of proceedings as far as possible to the needs of the existing state of society and to apply its jurisdiction to all those new cases which, for a progress of daily making in the affairs of men, must continuously arise, and not from too strict adherence to forms and rules established under different circumstances, decline to administer justice, to enforce rights for which there is no other remedy. In other words, you don't really need to have any form, you need to have substance. It doesn't really matter what the rules and so forth, said. We'll just do whatever we need to do. Because the court of equity, it's got all sorts of power. The basic jurisdiction of equity, the position of the state in relation to public welfare, and the consequential relation of the courts to the state are clearly illustrated by the Supreme Court of the United States in re Debs, DEBS 2, which is 158 U.S. 464. I might have to go read that. Anyways, hey, you can download this, right? Injunctions and receivership proceedings against illegal lenders. Emmett R. Field. Easy enough to find. Where was I at? Every government entrusted by the very terms of its being with the powers and duties to exercise and discharge for the general welfare has the right to apply its own courts for any proper assistance in the exercise of the one and discharge of the other, and is not sufficient answer to its appeal to one of those courts that it has no pecuniary interest in the matter. And it is not sufficient answer to its appeal to one of those courts that it has no pecuniary interest in the matter. The obligation which it is under to promote the interest of all and to prevent the wrongdoing of one insulting or resulting in injury of the general welfare is often in itself sufficient to give standing in court. So in other words, if they're not doing what they're supposed to, and you tell the court, hey, they're not doing what they're supposed to, right? That's all we're saying is they're not following the Constitution. Judge, I need you to application of receivership. And they look at it and say, you're right, they're not following the Constitution. Here, we'll do it for them. And they're going to step in and, take the place of the whoever is supposed to give you this relief you can't get and give it to you. Why the invocation of remedy of injunction by the state in loan shark cases is relatively untested procedure. The ingenuity of lenders and their counsel have failed to evolve any convincing defensive argument based on novelty of the situation. Defense usually urged are venerable ones which have been speedily presented in injunction case of all types, i.e. lack of sufficient standing, interest of petitioner or warrant to granting the relief prayed, the existence of adequate remedies at law, the supposed inability of courts of equity to enjoin criminal acts, the absence of property rights resting in the state, and the absence of facts characterize the lending activity as a nuisance. Right, even though they've tried to use that as a defense, apparently it doesn't work. The existence of necessary public interest is customarily recognized when the state sues to protect its own interest as a juristic person, but such recognition is not so readily afforded when it sues in vindication of social interest of the community at large, and it is the later field that loan shark cases lie. Not so readily afforded when it sues in vindication of social interest of the community at large. Although the question is seldom elucidated, the issue in most cases is not whether the court has jurisdiction to grant injunction, but whether it's within the very broad limits of its jurisdictional powers. It should, as a matter of discretion, do so, and the motivations of policy and expediency which influence one chancellor will be wholly without appeal to another. It appears, however, that whenever the court is made to feel that the continuing unlawful acts constitute direct threat to some recognized or important common interest, such acts will be enjoined. Courts may well differ in their views upon what constitutes a threat or injury to the public good, and upon what methods are most adequate in affording protection. But when the decision is once made, the remedy is not to be blocked by outmoded principles of validity, which arose in other settings, and the more courageous and enlightened courts have frankly taken such a stand. Their opinions are not always free of references to venerable doctrines superimposed in support of their decision, but the principle of the direct action is boldly employed with effective results. Anyways, so they do receiverships all the time. It's just, we're not asking in our case. We need to bring it to their attention. We're not telling them, hey, there's a problem. Not asking for injunctive relief. Okay, hey, hang on just a second. I don't know how much more of this one I want to read, but there may be some. All right, finding that the acts complained about constitute a public nuisance. Well, that'd be the first thing to say, that what they're doing is a public nuisance. While it is not stated, this fact clearly intensified the element of public wrong and conditions created and methods pursued by a lender tended largely to deprive borrowers of equal protection laws. In Kentucky, we did something. It was held that the state's obligation to protect the general welfare gave it sufficient standing in court. So what I had done in a Terry's court case was a federal court case, right? When you're filling out the because this is where we were opening up a court case. And when you fill out the civil cover sheet, one of the boxes you can check is that the United States is a plaintiff. And we did that. And it actually shows up in our court case with the United States being the plaintiff. So in her case, the state is, involved. And so the state could be the one asking for the receiver, right? A receiver may be appointed. If the right to injunctive relief is once established, the court may grant such other incidental relief as may be necessary to ensure effectiveness of the injunction. This is the whole thing. You got to get the injunctive relief established, and then you can get the receiver. A receiver may be appointed when necessary as an incident to a power to grant an injunction for the purpose of making an injunction effective and to provide complete and effective redress of wrongs to be remedied. It just says you have to ask for one, so we're going to try that. Just ask for a receiver. All right, that would be the next one I want to try. Just if you're already in a court case, don't do anything else other than write a one-line thing asking for a receiver. Put it in and see if they give you one. See if that changes the dynamics. Okay. Obviously, receivership is an in rem proceeding. If there is no property, there can be no receiver. But the involvement of the property in an equitable action is merely the incident which permits improper case for use of receivership process. Okay, the court's requirement that the petitioner must show a title or other definite material interest in the property or go without a receiver indicates a failure to comprehend the basic nature of receivership. Obviously, the receivership is an in rem proceeding. If there is no property, there can be no receiver. But the involvement of property is an equitable action, is merely an incident which permits in proper case the use of receivership process. The remedy is not employed as a means of determining the merits of a case or the title to the property between the parties, nor can it be used for either purpose. Its sole office in respect, so now we're talking about receivership. Its sole office in respect to the property is to hold it in status quo until the court can decide upon the merits of the action and thereby determine what the rights and interests of the parties in the property are. So if you ask for receivership, that gives the court the authority then to decide upon the merits. Stop arguing and make a decision. The remedy is an ancillary one, purely. Right? So it's subordinate to something else. You can't have receivership unless something else is going. So either you already have to have a court case going or you need to start a court case and ask for receivership. That was the way I was understanding this stuff as I was reading it. It is not the object of the action, but it is implementary means to attain of that object in which it is a tool which may be utilized by the court so that it may give complete and effective relief. Well, why are we here? For that particular reason, to get complete and effective relief. I don't know why they're there, but I know why you would be going. You want to get relief. The true definition of the process arises from its capacity of enabling courts to administer complete justice, and there is no other reason than that to have it done. The court have the right to employ their own process to maintain their integrity, and the remedy can hardly be accepted as part of our procedure on the shallow ground that it's merely a special prerequisite of litigants who are able to show proper interest. Anyways, that's pretty outstanding. I think I had one more to read. Hang on here. Let me go get that. Just a second. Okie dokie. Under this thing about receivership, I had two. And it says receivership in prison litigation context, right? And you can copy and paste that. And you can find that document online. And it says receivership in prison litigation context from 2010. So this isn't that old. All right, this article addresses the most invasive of judicial equitable remedies in institutional reform litigation. Okay, so they're talking about prisons. I'm talking about the VA or Social Security or the state of Michigan or whatever the other institution is. Unlike other equitable remedies, the receivership completely displaces the leadership of an executive agency in order to force it to comply with its constitutional obligations to the plaintiffs. That's some powerful shit, brother. This article is a comparative analysis of 3 receiverships in prison litigation context. Well, I ain't going to read those, right? But what he had to say beforehand is pretty good, right? They're trying to put the institution in receivership. I'm trying to put the case into receivership, right? Don't wait till you're in prison. Go to your case, even if your family member's in prison. Go to the case and put in for them to appoint a receiver to the case, because the case is never closed, right? The case is always open. They never close court cases until they issue a decree under a seal, follow the rules. Well, it ain't been closed yet. So the decades since Brown versus Board of Education has seen flourishing litigation aimed at protecting constitutional rights of people whose lives are administered in some way by government agencies. Vets, Social Security, state of Michigan makes you get a driver's license. Right? Everything. Anytime the government gets involved in your business, right? Well, then are they following the Constitution or not? That's all that matters. Regarding the object of litigation, there may be individual wrongdoers, but the target of the suit is on a social condition and also on bureaucratic dynamics that produced that condition. In other words, nobody has a proper oath of office. Right? Yeah, there's a guy doing the wrong, but he's doing the wrong because he don't have an oath of office. That's why he's doing the wrong. And that's a bureaucratic dynamic problem, which created the situation. So I'm going to try to get the court to take care of the whole enchilada. If the court finds that an executive agency has violated the plaintiff's class constitutional rights, the court often issues a structural injunction, a decree that recognizes the defendant institution. So right now the institution is the defendant. You're not the defendant. So that it will routinely deal with the plaintiff's class in a way that does not deprive them of their rights at issue. The court inserts itself into the management of a government institution to ensure compliance. Well, that's a pretty clearly written statement. The court inserts itself into the management of a government institution to ensure compliance. Outstanding. Court's equitable powers to fashion relief in civil rights litigation, in a word, broad, right? So you make it a civil rights, what is that, 42 U.S.C. 18? I can't remember the numbers, what civil rights is, but they got a number for 42 something or other. I have to go look. Except when constrained by constitutional prohibition or self-imposed considerations of comity, the federal courts have applied a full range of doctrines for structuring equitable relief to public as well as to private defendants, right? They can do what they need to do. They may be constitutionally prohibited or have some self-imposed standard, but they can, right? It's just how do you invoke it? The most invasive of these remedial tactics is a receivership. Receivership is an equitable remedy that has its roots in English chancery courts, where receivers were appointed to protect real property and monetary rents and profits. So they treat your body like it's real property, right? It's movable land. It's got a title. It's got your birth certificate. It's got a name on it. And then you have another one that's got an all caps name on it, right? Well, the all caps name and the proper case name, those are both just your property because you're not either of those. And you're not the movable land. You're not the animal human. You're the being and the human. You're a human being, right? Your human's your property. It's not their property. That's why you have a certificate. And they're just not letting us claim our property. So we're going to have it put in receivership and claim it. My goal is, I'm going to have them put Robert Allen Ritluski, my business, which I have an EIN for, into receivership, sell all the property, right, all the negotiable instruments that are being traded that, have this value, and just tell them to sell all the property and, give me a check, deposit it in my account. That's what Jesus said to do. He said, you should go sell all your property and give it to the poor, right? Give the proceeds to the poor. I'm in all 100%, Lord. That's exactly what I'll do, right? I'll go spend it into the economy. That's giving it to the poor. Right? You're taking better care of the sheep. If the shepherds would take their estate and put it into the economy, right, it would be better for everybody, into the real economy. So this is, how this will happen is eventually we'll give everybody back their property and you won't be making payments on houses and so forth because they never signed the contract. You don't have to borrow money to buy a house. It was done with your signature. You signed a promissory note. They took it. They stamped it with a paid the order of and turned it into a check, and then they deposited it. And it's payable in legal tender. Right? But right now it's just bank money. It's, the ones and zeros, the bank money. It's in the big purse, but it hasn't been put into the circulation as legal tender to be used in the economy. So however they want to give it back is up to them. I'm just saying, hey, that's my property and that's my rents and profits. I say it's mine. I want a receiver appointed to make a determination. And then they have to file, what did it say? Within 20 days under oath, right? They got to give a report to the clerk. Well, that's when you'll get your copy. While the court may appoint special masters or monitors to oversee administrative functions, receivers are the most powerful and independent remedy in court's arsenal to force an executive agency into compliance with its orders. Wow! Unlike the monitor and special master, the receiver completely displaces the defendants. The receiver makes large and small decisions, spends the organization's funds, and controls hiring and firing determinations. So we need, as veterans, we need to get a receiver over the veterans, as the military retirement fund, which has like $1 trillion in it. Right? And that is supposed to be going to people that are already veterans who get retirement pay. They're just not giving it to us. Everybody gets retirement pay at 60. It's part of the deal. Right? But I think because they never kick you out of the military, what they did with us, they put us on disability retirement. And then they have us sign a waiver to give it up to take the VA benefits instead. But they only give you a small percentage of what you should get. Well, now they have it so that you can have both VA benefits and disability retirement. So to have whoever the agency is over that fund put in receivership and let them figure out how we're going to get our money. Those types of things, right? I'm sure there's 1,000 things that this could be used for. But that's one of them, getting yours that's tied up in some account. Anyways, receiverships are strictly a remedy of last resort and have been called, for example, the nuclear option in prison reform litigation. Well, if it's the nuclear option there, it's always a nuclear option because nuclear bombs don't care. Close is good enough. Short of outright closure, it's the most invasive remedial tactic that a court in equity may employ to enforce its decrees. Wow, it's going to actually issue a decree, not just an order, not an opinion, a decree. Unlike large, small decisions, spend the funds, goes on and on and on. So this was 14. Where was 14? Short of outright closure, this is the most invasive remedial tactic that a court in equity may employ to enforce its decrees. And what did the read between the lines had to say about that? An equity court can impose 3 categories of measures to ensure compliance with its orders. First, a civil contempt sanction, in which the court can impose increasing levels of penalties on the defendant to coerce compliance. Second, the court can enjoin third parties from aiding the defendant in its noncompliance. And lastly, the courts may invoke in rem relief, in which the courts or its officers themselves do that which the defendant has refused to do. Outstanding. Continuing on, despite the existence of tests concerning receivership imposition, let's just read the whole thing. Case law concerning the receivership remedy for the reform of public institutions has developed a multi-pronged test over the past decades to guide the courts in deciding when to impose this receivership. Well, that would be, go read 15. Plaintiff finding a fact, which is a court case. If you put in plaintiff finding a fact, you'll find the court case, and it's got this long list of findings of facts. I haven't had a chance to read it yet, but that'll be, during the week. Once a court orders a receivership, it has almost unlimited discretion on whom to appoint, what powers to delegate the receiver, and how to supervise and track the receiver's performance. Once a court orders receivership, well, how do they do that? They do that when the party asks for a receiver. Application for receiver. Although the law restricts considerably the court's ability to order a receivership, once the court decides that receivership remedy is necessary, it is on its own. The court has wide latitude fashioning supervision and administration of the receivership. All right, so they restrict how they get to do it, but once it's been decided, well, it's, the floodgates open. While courts imposing receivership in real property context may draw upon lengthy history of the remedy to implement it, right? That's why you could use it in a foreclosure. They got a lot of history. That's where the common law on it started. Rooted in its equity, receivers may be granted powers that are broader and more flexible than those available under the bankruptcy code, right? So they're not in the bankruptcy code. They're separate from the bankruptcy code. However, the bankruptcy code was never intended to allow a court to administer a government agency. And that's what the receiver does. It administers a government agency. Wow, they didn't see that coming. This paper will illuminate the complications that arise when a court takes on over an executive agency. Well, we'll get that figured out. And then I went on about the breakdown of the prison system. This is really about, prison systems. So, hey, that's what's going on. I'm not going to argue with it. Hang on. Okay. Hey, just a few more bits that I had found that I'll throw them in here. 28 United States Code 3101 to 3105 has to do with this pre-judgment remedies. And it says in 3101, the United States may, in a proceeding in conjunction with the complaint, or at any time after the filing of a civil action on a claim of a debt, right? Civil action on a claim of a debt. So whatever your civil action is, it's a claim of a debt. Make application under oath to the court for issue of a pre-judgment remedy. And then it went on to give these, and one is a receivership. So, now how do you get the United States to be a plaintiff in the case so that the United States can be the one asking instead of you as a private party? And well, I did that in Terry's case, all right, where we put in, and the plaintiff was Terry Lynn Wilson and the United States. We made them both parties, right? So now the United States is, and so the idea was, well, the United States is the plaintiff, and Terry Lynn Wilson is the informant, the relator, right? Improper person talking for the United States. But now the United States is the plaintiff, so they should be able to apply for an appointment. So that was the idea with that. Is it this easy? Just put this in. Application for appointment of a receiver. Petitioner applies for a receiver to be appointed by the court due to whatever your reason is. Right? And this goes along with something you've already put in where you've complained about the action of the administrative agency or the bankruptcy or whatever it is. And this will all show itself maybe as early as tomorrow. So, okay, I don't know if I had anything else, but I'm going to take one more look and then we're just about done. Yeah, there were just a couple more things. So I think this shows the importance of, look, you need to send a copy of whatever you file into your court case, right? Not only to the defendant, or in this case, it would be the plaintiff's attorney, right, that you're going to file this paperwork, but also to the judge, because when we sent it to the judge, they put a receipt stamp on it, right? And that's all we did. We took a copy of what we had already filed with the clerk and mailed it to the judge, and the judge put it in the court case, right? She didn't send this back to Jackie. She put it in the court case. So you wouldn't be able to see these things unless you can see the docket of your court case and so forth. But this county's nice enough to show all this stuff, so outstanding. And if you're filing a civil cover sheet, right, here's where you check the box to make the United States a plaintiff. Right? You just, who is it? Right there. That's why we're here today. And because we did that, in Terry's case, they're still showing the United States as a plaintiff. So then we should be able to use the pre-judgment remedies, such as asking for receivership. But I have to go back and look at that. Something to do with a debt, it said. Right? That's the cause of action. Anyways, more on that later. I'll let you know what goes on, but I wanted to show you this in case somebody had to do something tomorrow, right? If you're going to court tomorrow, petition for a receiver and let the chips fall where they may, right? If you have fear that there's something that you're fearful of, well, then don't do anything. Just stand there and watch. It's going to happen soon enough anyways, so I'm just showing what it's based on. And I don't think I have anything else I can show you on this. Oh, I do want to show you one more thing on her case. Look, this is that case of Jackie's, right? Here's the parties. Look at all these people they made parties to that court case, right? All of these are supposed to be the full name of somebody, right? So this is supposed to be somebody's full name. There isn't any on here for just, Jackie and her full legal name. They have all these things. Here's the full name of Federal Deposit Insurance Corporation as receiver for Colonial Bank, FKA, Federal Colonial Bank National Association. That's the full name of the defendant. It's not the Federal Deposit Insurance Corporation. It's this thing they made using that name. United States of America acting through rural housing, right? This isn't the United States, isn't the plaintiff. It's this thing that was created using the name of the United States as a plaintiff. This is all the work of loan sharks. We're going to point them out in court. See how that goes. Okay, y'all have a great day. We'll see you later.